Over 2 days, the Caribbean Court of Justice listened to 10 hours of arguments in the legal dispute between the Government of Belize and 4 private liquefied petroleum gas companies. Senior Counsel Eamon Courtenay kicked things off, making the first submissions on behalf of the Attorney General of Belize.
There is an insinuation, to put it in the most anodyne way. Government was acting from a position of perhaps bad faith or ill will in seeking to put the respondents out of business. That is not so. The Amendment Act, Your Honors, is a clear piece of evidence that the government was not intending to put them out of business. The government was intending to move the supply of LPG from road to sea through a facility that advanced the purposes.
In the early stages of the legal battle, when the 4 companies were up in arms over NGC's operations, Parliament stepped in and amended the National Liquefied Petroleum Gas Project Act.
The government leveled the playing field on the importation side and provided the right for someone to apply for a license to import LPG through an approved facility.
However, the law only approves facilities with a storage capacity of 1.5 million gallons. The LPG companies argue that this requirement isn't economically feasible for them. Attorney Douglas Mendes, representing his clients, claimed that while there's an option for these companies to import through NGC's facility, it's just a pretense.
By imposing impossible or commercially unviable, if that's a word, conditions to enter the market, you in effect maintain the monopoly. And that is the point that we make. So the monopoly still exists because you have on the face of it, it's written in the act that you're permitted entry, but you really can't enter because it is financially prohibitive, as the evidence indicates, to build a 1.5 million gallon plant, and just simply does not make sense to have us import through the NGC's terminal when that relationship is totally unregulated.
When the National Gas Company Limited was established, a decision was taken to import LPG exclusively by sea from the US to the company's port facility. This brought an end to the trucking system that the private companies had in place. Attorney for Appellants Senior Counsel Angeline Welch argued that this approach decreases the risk of supply shortages, provides for cheaper gas, and places the supply chain in the hands of Belizeans.
The LPG was shipped to terminals in Guatemala, Honduras and El Salvador, and then it was trucked into Belize. By the time the LPG was trucked into Belize, the cost of the LPG to the end customer in Belize was the Mont Belvieu price and the cost of those terminals and the transportation, plus any profit element. So as Mr. Courtenay explained, the supply chain was operated and controlled by sister companies of the LPG companies. So those costs for the terminal, the transportation, and any profits made were for that oligopoly which existed before the legislation.
But the attorney for the 4 companies, Godfrey, argues that the move violates his client's right to work.
The right is hindered. It is fettered. What the Constitution guarantees to the respondents is that you have unfettered, unhindered right to engage in a trade or business that you freely choose.
Right.
So that they freely choose.
Right, but it's
importation.
After a long 9-hour hearing, Senior Counsel Eamon Courtenay wrapped up his remarks to the court by addressing Mendes' claim that the new law is just for show.
Mr. Mendes, my learned friend, took the liberty of alleging that the act and the amendment were pretenses, or certainly the amendment was a pretense by the government, and to fake the fact that it was opening the market. A simple read of the legislation will show that it was the intention of the government to liberate the market on the conditions set out in there. There is absolutely no basis to support the allegation, and I urge this court to reject it out of hand.
In his closing statement, Mendes requested that the court consider if the playing field is leveled.
As the legislation treated the respondents and NGC in an even-handed manner. That's basically what it is. And therefore, you have to look, what are the attributes relevant to the question of being able to meet the requirements of a 1.5 million gallon storage plant? How are we, what are our comparable circumstances relative to that requirement? And the answer to that is they have all these benefits.
Reporting for News 5, I am Paul Lopez.